International Economic Law. So here we go on the first page of this chapter. The Bretton Woods Agreement. Bretton Woods Agreement, one of the contributor of the modern multilateral international economic system, way back Second World War. The Bretton Woods Agreement became their way to protect the international economic system. And here, the International Monetary Fund, International Bank for Reconstruction and Development, International Trade Organization were created. Second one is the International Monetary Fund. International Monetary Fund were formally established on December 1945 by the virtue of Bretton Woods Agreement. The primary purpose is to ensure the stability of the international monetary system in a way na ma-extend ang loans sa mababang rate. Third are the World Bank Group. World Bank ang mas famous pinakakatiwalaan ng mga countries and corporations and highly accessible ng mga bansa. World Bank is the specialized agency under United Nations. Ang purpose nito ay para ma-promote ang economic growth and trade equilibrium sa pag-facilitate ng mga investments for capital. Because of the World Bank, Europe was reconstructed after the Second World War. The fourth one is the United Nations. United Nations, the International Labour Organization and the International Maritime Organization are two organizations that have an impact on the development of international economic law. Given its size, goals, aim, and collaboration with other specialized agencies, the United Nations will be the most important of these organizations. And the last one is the Organization for Economic Cooperation and Development. The Institution for Economic Cooperation and Development, or also known as OECD, is another prominent organization involved in international economic law. The Organization for Economic Cooperation and Development was founded in 1961 as a descendant to the Organization for European Economic Cooperation. Its goal is to empower growth, highly employment, economic freedom, and a trading system that promotes plurilateral and fair and equitable dealings between nations. Despite the fact that the OECD only has 35 members at the time of writing, and that the majority of these members are wealthy nations, or developed countries. The OECD has contributed to the emergence of international economic law by providing economic study and financial guidelines to aid capital flows and global corporations. Thank you.
Hello, good day. I am Kian Paulo Arpus, your reporter for the International Economic Law under Diplomatic and Consular Practice. Economic integration involves agreement between countries that usually include the elimination of trade barriers and aligning monetary and fiscal policies, leading to a more interconnected global economy. Thus, economic integration is consistent with the economic theory, which argues that the global economy is better off when markets can function in unison with minimal government interventions. Also, economic integration is beneficial in many ways as it allows countries to specialize and trade without government interference, which can benefit all economies. It also results in a reduction of cost and ultimately an increase in an overall wealth. With this, trade costs are reduced and goods and services are more widely available, which leads to a more efficient economy. And an efficient economy distributes capital, goods, and services into the areas that demand them the most. Nationalists, or people who believe that their country is superior to others, are critical of economic integration. In order to appeal to the nationalists, some countries employ forms of protectionism, which leads to higher tariffs and less free trade between other countries. Now we are heading to the notable features of the economic integration. The notable feature of economic integration is the loss of individual central banks who control monetary policy. It leads to less national sovereignty, and the responsibilities of central banks are delegated to an external body. Instead, the external control becomes troublesome in terms of managing a cohesive fiscal and monetary policy among many different countries. Okay, so we are now heading to the next part of the report, which is the definition and examples of the GATT. The General Agreement on Tariffs and Trade was a free trade agreement that eliminated tariffs and increased international trade. As the first worldwide multilateral free trade agreement, the GATT governed a significant portion of international trade between January 1, 1948 and January 1, 1995. The agreement ended when it was replaced by the more robust World Trade Organization, or the WTO. For example, if the US were to trade with one of the other members of the GATT, it would eliminate any tariffs that normally would have been imposed prior to the formation of the trade agreement. Okay, so I believe some of you may still be wondering how the GATT works. So the purpose of the GATT was to eliminate harmful trade protectionism, which likely contributed to the 66% reduction of the global trade during the Great Depression. The GATT helped restore economic health to the world after the devastation of the Depression and World War II. So the GATT had three main provisions. The most important requirement was that each member would confer most favored nation status to every other member. All members had to be treated equally when it came to tariffs. The agreement excluded the special tariffs among members of the Commonwealth and customs unions. It permitted tariffs if the removal would cause serious injury to domestic producers. However, the GATT prohibited restrictions on the number of imports and exports. The exceptions were when a government had surplus of agricultural products. Also, if a country needed to protect its balance of payments because of its foreign exchange reserves were low. Emerging markets, countries that needed to protect fledgling industries. Those are the exceptions provided by the GATT. In addition, countries could restrict trade for reasons of national security. This included protecting patents and public morals. The third provision was added in 1965, addressing developing countries joining the GATT. With this, developed countries agreed to eliminate tariffs on imports from developing countries to boost those economies. Lower tariffs had benefits for developed countries, as well as the GATT increased the number of middle-class consumers throughout the world. There was also an increased demand for trade with developed countries. Although the ITO never materialized, the GATT proved remarkably successful in liberalizing world trade over the next 5 decades. By the late 1980s, there were calls for a stronger multilateral organization to monitor trade and resolve trade disputes. Following the completion of the Uruguay Round 1986 to 1994 of multilateral trade negotiations, the WTO began operations on January 1, 1995. The WTO has 6 key objectives. First is to set and enforce rules for international trade. Second is to provide a forum for negotiating and monitoring further trade liberalization. Third is to resolve trade disputes. Four is to increase transparency of decision-making processes. Five is to cooperate with other major international economic institutions involved in global economic management. And six is to help developing countries benefit fully from global trading system. Although shared by the JATT, in practice, these goals have been pursued more comprehensively by the WTO. For example, whereas the JATT focused almost exclusively on goods. Though much of agriculture and textiles were excluded, the WTO encompasses all goods, services, and intellectual property, as well as some investment policies. So, now we are already on the last part of the report, which is the Agreement on Trade-Related Investment Measures, or the TRIMS. Or the TRIMS recognizes that the certain investment measures can restrict and distort trade. It states that the WTO members may not apply any measure that discriminates against foreign products or that leads to quantitative restrictions, both of which violate basic WTO principles. A list of prohibited trims such as the local content requirements is part of the agreement. Furthermore, the TRIMS Committee monitors the operation and implementation of the agreement and allows members the opportunity to consult any relevant matters under the said topic. With regards to the objectives of the agreement, as defined in its preamble, include the expansion and progressive liberalization of world trade and to facilitate investment across international frontiers so as to increase the economic growth of all trading partners, particularly developing countries, members, while ensuring free competition. That is the objective of the international economic law.
Okay, so before I continue our group's report, I would like to greet first our instructor a very, very nice day. For this part, I will be discussing the chapter 14, which is the international economic law of this book, starting from letter J to letter N of this chapter. This part starts with the General Agreement on Trade and Services, or the GATS or GATS. Unlike GATT or the General Agreement on Tariffs and Trade that is focused on goods, GATS or GATS is talking about the negotiations of one country to another regarding services. But they are also alike since both of these two contains provisions like most favored nation or the MFN principle, safeguard measures, and both of these two also contains provisions on general exceptions. Under this, there is trade and services wherein contents about supply for services is stated. There is also schedule where schedule or terms, limitations and conditions on market access, conditions and qualifications on national treatment, and time frame for implementing these conditions are asserted. The next one is the commitment, which is divided into two, which are the general and the specific. General means that the commitment is applied to all the members, like MFN, transparency, flexibility for developing countries, while specific is only applied to members in a specific sector. General is applicable to all the members whether or not they have undertaken commitment, while specific is applicable to the commitment that the state has undertaken. And the next one is the modification of commitment where notice for intention and withdrawal should be known by the Council for Trade and Services. And the last one is the commitment of the Philippines, which states that the Philippines is known to commit in sectors like tourism, transport, insurance, finance, and telecommunication services. Moving on to the next letter, which is K, trade facilitation. It talks about the improvements of procedures and controls to reduce costs and to make sure that the objectives will be consistently met. Under this, there is the 2013 Bali package. According to this book, This agreement is the first multilateral trade agreement since the World Trade Organization was established, causing it to be historic. This agreement has covered many trade agreements and is now aiming to achieve uniform rules for all members that would streamline customs or port procedures. However, there are criticisms. One of its criticisms is that 2013 Bali package is meant to help poorer countries, but it is already implemented to richer countries. Thus, poorer countries will be burdened since they will be the one to adjust in many sectors like infrastructures. In simplest words, this agreement was criticized because this agreement aims to help poorer countries, but its rules is not suitable for poorer countries. So the next letter is L, which is the tariffs. This book defined tariffs as a tax on imports and exports. This book also stated that tariffs can be a way to increase revenues, and it can also be a way to affect competition and trade. There are three types of tariffs, which are the ad valorem, specific, and the mixed. Ad valorem is the most common method that is used in determining duties. It is a method that is imposed on according to the value of the goods as a whole, while the specific is a tariff that is imposed according to the value of each and every good. And the last one is the mix, which is the combination of both the ad valorem and the specific. The negotiations for tariffs is usually done in a product by product basis. With this, current, supply, demand, and the production of the product are all considered. Duties for tariffs are the taxes levied on imports and exports. There is also bound tariffs that are essentially MFN rates due to the fact that they are the maximum tariff rates allowed by the World Trade Organization. Moving on to the next letter, we have customs regulations. This book defined this as the restrictions on imports and exports of goods. For the customs valuation, the adjustments of fees and other costs is discussed. Under this, there are also other methods. When the actual transaction value cannot be ascertained, examination on the value of identical goods and similar goods will be obtained. But if not, deduction methods, computed method, and fallback method will be executed. For the last letter of my discussion, which is letter M, the safeguard measures, there are emergency measures. This is a temporary measure to give relief to a domestic member during emergency situations. Safeguard measure is also called escape clauses because members can escape from their obligations under GATT under specified situations. The elements for this measure should be justified by showing increase in imports, serious injuries, and causation. And here, let us remember that the damage done or the actual damage done is not a necessary requirement for a state to employ safeguard measures. The important things are the elements that I have stated earlier. There are also primary documents that are significant on the agreement on safeguards. For the developing states exception, safeguard measures are generally employed against all states from which imports are arriving, but there is an exception for developing countries. It is stated in the Article 9 of the Agreement on Safeguards. This exception is a narrow exception wherein developing countries can have extended safeguard measures for 2 years. And the last one for this is the gray area measures, which talks about trade barriers. It is meant to protect domestic industries. However, today, gray area measures are officially considered unlawful. So those are for my discussion. The next letters or contents of the chapter 14 of the book will be discussed by the next presenter. Thank you.
So the next part of our presentation is all about the anti-dumping measures. So what is this anti-dumping measures? So we seek to nullify the harm done by dumping and are usually directed specifically towards the country from which the enterprise is engaging in dumping, even if the state itself is not directly responsible. So there are elements in dumping. First, there must be an actual dumping, a material injury, and a link between dumping and the injury. So anti-dumping measures are governed by the provision of Article 6 of the GATT, or the General Agreement on Tariffs and Trade, as well as the Anti-Dumping Agreement as a primary documents. So there is also a provision in the Philippines, the Anti-Dumping Law, or the Republic Act number 8751, and later on adopted under Article 711 of the CMTA. So what is this countervailing duties? So these are meant to offset the unlawful advantages created by illegal government subsidies. There is also a provision in the Philippines, the Countervailing Duties Act 8751, and adopted under Article 713 of the CMTA. So discrimination by foreign countries under Article 714 of the CMTA mandates the President, without prejudice to the Philippine commitment in any international agreement or treaty, and should public interest be served, to declare new or additional duties in an amount not exceeding 100%, and whenever the President finds any fact that a country imposes direct or indirect disposition or transportation in transit or through exportation from such country of any goods or product of the Philippines, any limitation, unreasonable charges which is not equally enforced. The President shall find that any foreign country has not only discriminated against the commerce of the Philippines, but has, after the issuance of a proclamation as authorized in subsection, the President is authorized to issue a further proclamation directing the products of the said country imported in their vessels be excluded from the importation in the Philippines. The United Nations Convention on Contracts for the International Sale of Goods, also known as the CISG, is an international agreement which seeks to harmonize the law on the sale of goods between parties in different jurisdictions. So the purpose of the CISG is that it was created in order to uniform rules regarding international sales to contracts, to promote international trade, and remove legal barriers that hinder the same developing. So the CISG is still a treaty, therefore it is only binding states who have bound themselves to it. So the scope under Article 1, Paragraph 3 only applies to sales involving parties whose places of business are in different states. Based on Article 1, Paragraph 3, neither the nationality of the parties nor the civil character of the parties should be taken into consideration when determining the applicability of the CISG. So under Article 10, if a party has more than one place of business, the place of business shall be at the closest relationship to the contract. However, if a party has no place of business, reference should be made to habitual residence. Under Article 2, restricted applicability does not apply if sales of goods bought for personal, family, or household use, sale by auction, execution, stocks, ships, and sales of electricity. Under Article 11, there are no formal requirements for a sales contract. It can be proven using any means including witnesses. Under Article 4, it is only interested in delineating the rights of the parties arising from the contract. Under Article 5, is expressly not be applied to the liability of the seller from death or personal injuries caused by the goods involved. Under Article 7, the need to promote uniformity in its application. In Article 8, Paragraph 2, statements of a party should be interpreted based on the understanding of a reasonable person. So in connection with this provision, under Paragraph 3, it also appears to allow circumstantial evidence to aid in the interpretation of statements when it is provided that due consideration should be given. So in Article 15, the contract of sale is concerned and any offer considered irrevocable can still be revoked provided the withdrawal reaches. Although the Philippines has a Competition Act in the form of Republic Act number 10667, the threats faced by domestic corporations among themselves are nothing compared to the threats they face from the foreign corporations. Furthermore, existing domestic monopolies are left unchecked since the law remains prospective. Given the infancy of this law, it remains to be seen its true impact on the Philippines and to the global market.